This courtroom hearing starts off quietly. Paperwork, case numbers, technical confusion, but within minutes, it turns into a brutal breakdown of repeated probation violations, failed drug tests, and behavior so shocking that even the judge seems visibly frustrated. The defendant, Cynthia Campbell, is already on deferred probation for aggravated assault with a deadly weapon, which means she was previously given a chance to avoid prison time. But now, prosecutors are back with a motion to revoke that probation completely. And once you hear the list of allegations, you'll understand why this hearing escalates fast. What makes this case especially intense is how quickly the defendant admits to nearly every violation without hesitation. Failed drug tests involving methamphetamine, cocaine, and THC, missed screenings, failure to report address changes, failure to complete treatment, unpaid court fees. One by one, the admissions pile up, and the courtroom atmosphere shifts from procedural to devastating. The judge isn't just reviewing paperwork anymore. She's deciding whether this defendant deserves another opportunity or whether prison is now unavoidable. And later in this hearing, things become even more uncomfortable when jail behavior allegations are discussed openly in court. The judge questions whether the defendant has any respect for rules or authority at all, and the exchange that follows is awkward, tense, and impossible to ignore. So the big question becomes, at what point does a court decide enough chances have already been given? And if you were the judge here, would you still consider probation after hearing all of this?
Cynthia Campbell. I need a clean one so that I can write on it. Thank you. Hang on just a second. Unless, was it filed back in 2023? Or is that another one?
March 25.
Okay. It's not on here.
Here it is, 5/23.
No, we need one from 25.
Okay, I'm sorry, Judge.
There should be a new one. March 4th of 25 I've got. Oh, wait. This is probably it. Do you see that 22-40282? I don't know who names those, but
That's how it was e-filed. Sorry.
that's okay. So who e-files them? Them?
Yes.
Okay. Would you make a
folds.
note so we can make sure they know that they need to call it what it is?
Yes, ma'am.
It is called the case.
No, it's, so on my screen, it doesn't say motion to revoke. It just says the cause number and PDF dot 3 pages. It doesn't say that it's the motion to revoke, so I don't know what it is. So I need it called that so I can find it, because we're paperless and it's easier. Okay. Yeah. All right, you're Cynthia Campbell. I got it now. Thank you. And will your client waive the formal reading of the motion?
She does, Judge.
All right, let me get my stuff together here. Ms. Campbell, in cause number 22-4028.
Shocking confession in fatal accident case, defendant accepts responsibility and faces up to 15 years prison.
I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 12th of 2022 for the offense of aggravated assault with a deadly weapon. And that was a 10-year deferred probation. Is that correct?
Yes, Your Honor.
I'm getting there. It alleges that you violated your probation. Count 1 alleges that you failed to avoid persons or places of disreputable or harmful character, specifically avoiding association with any person previously convicted of a crime or being at any location where a crime was committed. And is that true or not true?
Yes, Your Honor.
True or not true? Thank you.
Probation consequences.
Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
True.
Count 3 alleges that you failed to immediately report to the probation officer your new address. Is that true or not true?
True.
Count 4 alleges that you provided a urine sample January 6th of 2025 that tested positive for methamphetamine, amphetamine, cocaine, and tetrahydrocannabinol. And is that true or not true?
True.
Count 5 alleges that you provided a urine sample January 8th of 2025 that also tested positive for methamphetamine, amphetamine, cocaine, and tetrahydrocannabinol. And is that true or not true?
True.
Count 6 alleges that you failed to successfully complete treatment at the Melton Center for intensive inpatient treatment. Is that true or not true?
At this point in the hearing, the damage to the defense case is becoming nearly impossible to control. The defendant has now admitted to repeated probation violations across multiple categories. Not just one mistake, not just one failed drug test, but a pattern of conduct that shows ongoing non-compliance with nearly every major condition of probation. And legally, that matters a lot. Deferred probation is essentially the court saying, we're willing to hold off on a conviction if you follow strict rules. But once those rules are repeatedly violated, judges often view it as proof that rehabilitation efforts are failing. What really stands out here is the sheer range of violations: drug use, missed screenings, failing treatment, failure to maintain employment verification, failing to report address changes. This isn't a single lapse in judgment. Prosecutors are building the image of someone who continuously ignored court supervision. And notice how direct the judge is during questioning. There's no dramatic argument from the defense, no attempt to deny the allegations. The answers are short, clear, and devastating. True, true, true. That creates a major psychological impact in the courtroom. Every admission strengthens the state's argument that probation is no longer working. And viewers should remember, aggravated assault with a deadly weapon is already an extremely serious offense. The court originally gave this defendant a chance to avoid prison. Now the question becomes whether that chance has officially run out.
Or not true?
True.
Count 6
Emotional sympathy.
alleges that you failed to submit to alcohol or drug screening November 16th and December 9th of 2024, and then January 7th, January 14th, January 24th, and January 28th of 2025. And is that true or not true?
True.
And then count 8 alleges that you're behind in your court-assessed fees. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 8 freely and voluntarily?
Yes, Your Honor.
And did you plead true to those counts because they're all actually true?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
This is the moment where the hearing fully shifts from probation review to sentencing reality. Once the judge formally accepts the pleas of true and finds sufficient evidence, the legal protection of deferred adjudication essentially disappears. That's huge. The defendant is no longer simply accused of violating probation. The court is now officially entering a conviction for aggravated assault with a deadly weapon. And with that comes prison time, firearm restrictions, and a permanent criminal consequence that can follow someone for life. What's interesting here is how calm and procedural the judge remains while delivering such life-changing consequences. There's no yelling, no dramatic outburst, just a methodical explanation of rights being waived, prison time being imposed, and future restrictions under Texas law. But honestly, That calm delivery almost makes the moment feel even heavier. 5 years in prison is now real, and the defendant's repeated violations clearly played a massive role in getting to this outcome. The firearm warning is also significant. A lot of defendants focus only on the prison sentence itself, but felony convictions create long-term consequences long after release. Restrictions on firearm possession, employment opportunities, housing, and future supervision all become part of the equation. The court is making it very clear.
Of
This
respect.
sentence
And,
doesn't just affect the next few years, it
hold on a
reshapes
second,
the
just lost
defendant's
it.
future entirely.
There we go. Okay. And it's for a term. Okay. State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Campbell's not competent?
No, Judge.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. I am making an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also
Final judgment delivered 6 years prison after rejected probation request. Courtroom tension reaches peak.
handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. All right, good luck to you, ma'am. You can go back with the bed.
The actions in the jail clearly show he doesn't have any respect for authority or rules. I don't feel like he's a proper candidate for probation, so we're asking for a 6-year sentence in TDC.
So, Mr. Lewis, one thing I noticed in several of these letters that friends and family members
Serious murder charges lead to rejected plea deal. Defendant chooses trial risking life sentence.
said, I think 3 of them actually used the word respectful, that you're a respectful young man. What has been going on in our jail is the furthest thing from respectful that I've seen. The number of times, and the fact that I have to say this out loud, the number of times that you choose to masturbate in front of the officers on purpose is ridiculous.
I speak on the,
Sure.
the case wasn't on me. Somebody else had a case, and the woman even talked to the lieutenant to get it removed up off of my file, but it still shows up. That was not on me. It's somebody.
It's more than
This may be the most uncomfortable section of the entire hearing. Up until now, the courtroom discussion focused mostly on probation violations and sentencing. But once the judge begins discussing the defendant's behavior inside the jail, the tone changes dramatically. The judge directly challenges the idea presented in support letters that the defendant is respectful, and then immediately contrasts that with allegations of repeated misconduct toward jail staff. That contradiction appears to genuinely frustrate the court. From a legal standpoint, behavior while incarcerated can absolutely influence sentencing decisions and probation considerations. Judges often look at jail conduct as an indicator of whether someone is capable of following rules under supervision. And here, the court is essentially saying, if you cannot follow basic rules inside a controlled environment, why should the court believe you'll succeed on probation outside of jail? That's a devastating position for the defense to overcome. What also stands out is the defendant's attempt to explain away at least one of the allegations by claiming the incident involved someone else. But notice how quickly the judge responds by pointing out there were multiple incidents documented. That exchange matters because credibility becomes everything during sentencing hearings. Once the judge begins doubting the defendant's explanations, it becomes much harder to argue for leniency. At this stage, the courtroom atmosphere feels less like a debate and more like the court reaching a final conclusion about accountability.
One time.
But I,
So hold on. So on April 14th, let's just go through them. On April 14th, you were in trouble for
Repeated probation violations, drug use, and failures lead to 5-year sentence. Judge closes case with firm authority.
not being in your bunk, that you had been given several orders to go to your bunk. You proceeded to walk around yelling, "Bitch, stop talking to me." So that's from April 14th, last week. Then on April 7th, it alleges that you had your hands in your pants, moving in and back and forth, that you were told to take your hands out of your pants, and that you had been told before, or this officer had been briefed on the fact that you were known for doing this.
By the end of this hearing, the outcome becomes painfully clear. The court believed repeated probation violations, failed drug tests, missed treatment obligations, and ongoing misconduct demonstrated that probation was no longer an appropriate option. Cynthia Campbell's admissions to multiple violations gave the judge more than enough legal grounds to revoke deferred probation, enter a conviction for aggravated assault with a deadly weapon, and impose a prison sentence. What started as an opportunity to avoid incarceration ultimately ended with years behind bars and long-term felony consequences. This case is also a reminder of how probation works in the real world. Courts often give defendants second chances, but those second chances come with strict conditions. And when violations begin stacking up repeatedly, especially involving drugs, missed reporting, and behavioral problems, judges may decide public safety and accountability outweigh rehabilitation efforts. The hearing also showed how courtroom credibility matters. Every answer, every explanation, and every documented incident can influence how a judge views a defendant's future. And now, we want to hear from you. Do you think the judge made the right decision here, or should another chance have been considered? If you found this courtroom breakdown intense, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom commentary and legal case breakdowns.